Every detail matters in the courtroom. Every perspective demands fairness. Know your legal protections and pursue genuine justice.
Excuse me, what exactly are you doing in this neighborhood?
I'm sorry, what? I'm just walking to my car.
Don't act dumb. This is a private community and I know you don't belong here.
Ma'am, this is a public street. I live 3 houses down from here.
I'm calling the police. You are way too suspicious.
You're free to call whoever you...
It was a quiet Saturday morning in the neighborhood. The kind of morning where the silence of residential streets is only broken by the wind carrying autumn leaves across the sidewalk. Cars sat in driveways, houses were still, and everything had that deceptive appearance of a place where absolutely nothing could go wrong. It was October 14th, 2023, exactly 11:23 in the morning, and a security camera installed near the community mailboxes was recording everything in high definition, with no one around yet understanding the weight that footage would carry in the weeks to come. Diana had just returned from a yoga class. She was in workout clothes, carrying her rolled purple mat tucked under her arm, and was heading to the mailboxes the way she did every week. There was nothing extraordinary about that moment. She lived there, paid her HOA fees on time, and had the key to the box with her own house number engraved on it. She was a resident like any other in that neighborhood. But when a neighbor appeared, a blonde woman in a denim jacket with her arms crossed and an expression that left little room for ambiguity, what should have been an ordinary morning turned into something neither of them would ever forget. The neighbor approached with the posture of someone who had already made up her mind before she even opened her mouth. There was no friendliness, no casual greeting that you'd expect between people who had shared the same neighborhood for months. There was only that tense, accusatory energy, the kind that any black person who has ever lived in a predominantly white space recognizes immediately. It doesn't need to be spoken out loud. It lives in the body, in the gaze, in the way someone treats you as though you need to justify your presence in a particular place simply by existing there. Diana knew that energy. She had felt it before. And she understood, in that exact moment, that she needed to choose very carefully how she was going to respond. What the neighbor didn't know, and this is the detail that changes everything in this story, is that Diana wasn't just a resident of the neighborhood. Diana was a lawyer, not just any lawyer. She was a specialist in real estate law, a field that deals precisely with property, ownership, housing rights, and everything surrounding the legal space a person has the right to occupy. In other words, the woman being questioned about whether she actually lived there spent her weekdays defending other people's rights to their own properties. The irony was almost impossible to believe. Before we go any further, I need to ask you something. If this is your first time on this channel, welcome. This story gets far more intense than these first few minutes suggest, and you are going to want to stay until the end. Hit subscribe right now and tell me in the comments if you have ever been through something like this. If you have ever been treated as though you didn't belong somewhere, you had every right to be. It could be a neighborhood, a store, a hotel, a restaurant. Tell me down below, because this conversation matters. The security camera kept recording as the two women stood there on the sidewalk near the mailboxes, autumn leaves behind them and the cloudy October sky above. Within minutes, that footage would stop being just a file in a residential monitoring system and become evidence. Evidence of something that happens with alarming frequency in neighborhoods, shopping centers, elevators, and streets across the country, but that is rarely captured with such clarity. And when that video reached the right hands, the life of one of those two women on that sidewalk would never be the same again. Diana grew up understanding that competence was not enough, that diplomas on the wall were not enough, that an address in a good neighborhood was not enough. She had learned this not in a classroom, but through life. Through the small daily humiliations that accumulate in silence over the years and shape the way a black person learns to move through the world. She had built her career with an almost stubborn discipline, spent years studying real estate law, built a solid reputation, and bought her home in that neighborhood not by chance, but because she had worked for it with a determination that most people would never need to have. And yet, there she was, on the sidewalk, being questioned. The neighbor who approached that morning was named Susan. She had lived in the neighborhood for several years and had apparently developed over that time a kind of ownership over the surrounding space. The territorial comfort that certain people build without ever realizing it rests on the assumption that some people belong and others do not. Susan was not at least on the surface, what most people would picture when they think of someone racist. She did not shout. She did not use slurs. She simply walked up to a neighbor who was checking her mail and began asking questions in a tone that made clear these were not real questions at all. They were demands dressed up as curiosity. What makes this kind of situation so devastating is not obvious violence. It is exactly the opposite. It is the way everything unfolds in a controlled tone of voice, in language that sounds reasonable on the surface, but carries underneath it an absolutely clear message. Prove that you have the right to be here. This dynamic has a name. Researchers and behavioral specialists call it everyday racism or microaggression. But the technical term fails to capture the real weight of what it is to be on the receiving end of that experience. It is not micro for the person living it. It is exhausting. It is humiliating. And it happens with a frequency that people who have never experienced it simply cannot imagine. Diana stood there listening to Susan's questions with a calm that anyone who knew her would understand came at a cost. She was a lawyer. She spent her days navigating conflicts, negotiations, situations where keeping composure was the difference between winning and losing. But there is an enormous difference between maintaining composure in a conference room or a courtroom, and maintaining composure when someone is treating you like an intruder in the place where you sleep, where you keep your things, where you have the absolute legal right to be. Even so, she did not lose control. She responded. She explained. And at some point during that exchange, she did something Susan certainly did not expect. She made it clear that she knew exactly what her rights were. Have you ever stopped to think about how many times a day Black people have to make that calculation? How far do I go? How much do I explain? When do I stop justifying myself? It is not a simple decision. There are consequences in every direction you choose. If you back down, the situation repeats itself because it went unpunished. If you respond too firmly, you become the problem. If you draw attention to the injustice, you are told you are overreacting, that you are being sensitive, that you are seeing racism where none exists. It is a trap designed to have no exit, and Diana knew every corner of it. What Susan had not calculated, not for a single moment as she stood there with her arms crossed, asking her questions on that October morning, was that the security camera positioned near the mailboxes was capturing everything. Every second of that interaction was being recorded with the date and time stamped in the upper right corner of the frame. And what the camera showed was not an ambiguous situation open to interpretation. What it showed was one woman approaching another in a shared public space with no legitimate reason, with body language that told a very specific story about what she truly thought about having Diana as a neighbor. That footage was about to become the center of everything. When Diana walked back into her house that morning, she did not go straight to the kitchen to make coffee or turn on the television the way she would have on any other normal Saturday. She sat down. She was quiet for a moment. And then she began to process what had just happened with the analytical mind of someone who spends their professional life dismantling situations and identifying what is truly at stake. She knew that what Susan had done was not just unpleasant. It was potentially illegal, and she knew, with the precision of someone who understands the law from the inside, exactly which paths were available to her in that moment. The first step was to check the security cameras. The neighborhood had a monitoring system in common areas, including the mailbox area, and Diana knew this. She had noticed the cameras before, the way people who pay attention to their surroundings tend to notice these things. When she confirmed that the camera was positioned directly over the location where the conversation had taken place, she understood that she had something concrete. It was not just her word against Susan's word. There was a recording. There was an objective record of that moment, with date, time, and image clear enough to show exactly what had happened and how it had happened. Getting access to that recording was not immediate. It involved contacting the neighborhood association, making a formal request, and navigating the bureaucracy those requests typically entail. But Diana was a lawyer. She knew how to make formal requests. She knew what her rights were as a resident regarding access to recordings from common areas. And she knew that every hour that passed without that file being preserved was an hour in which it could be overwritten or deleted by the system's automatic rotation. She acted with urgency, but with method. No agitation, no confrontation, just the quiet efficiency of someone who knows exactly what they are doing. While she waited for the footage, Diana began documenting everything she could. She wrote a detailed account of the conversation, while the memories were still fresh, noting not just what was said, but the tone, the posture, the sequence of events. She photographed the mailbox area. She identified which neighbors might have seen or heard anything. This documentation process might seem excessive to anyone who has never had to prove they were the victim of something that leaves no physical marks. But Diana understood that in situations like this one, where discrimination happens in carefully controlled language and without obvious witnesses, the difference between being able to hold someone accountable or not almost always comes down to the details most people dismiss as irrelevant. The video arrived, and when Diana watched that footage for the first time, sitting in front of her computer with the file finally open on the screen, what she saw confirmed everything she had felt on that sidewalk. The camera had captured Susan's approach with unsettling clarity. You could see the body language, the crossed arms, the expression on her face, the way Susan had positioned herself in relation to Diana in a manner that anyone watching would recognize as confrontational. There was no ambiguity in those images. There was no way to watch that video and conclude that what was taking place was a friendly conversation between neighbors. What was happening there was an interrogation, and the reason for that interrogation was implicit in every second of the recording. Diana sent the video to several professional colleagues that same evening, not to ask for their opinion about what had happened. She already knew what had happened, but to assess, with other trained eyes, what the smartest strategy would be from that point forward. The responses were unanimous. What the footage showed was sufficient to support a formal complaint with the Neighborhood Association for Racial Discrimination, and possibly far more than that. One colleague who watched the video said something that stayed with Diana for days, that Susan had made the classic mistake of people who act on prejudice and have never been held accountable before. She had acted as though there would be no consequences, as though no one was watching, as though the entire world could not see. The formal complaint was filed on a Monday morning, 2 days after the incident. Diana arrived at the Neighborhood Association's management office with a carefully drafted document, the detailed account she had written on Saturday, and a preserved copy of the recording. The person who received her on the other side of the counter clearly had not expected that level of preparation. They had not expected precise legal language, had not expected specific references to the clauses in the neighborhood's internal regulations, prohibiting discrimination among residents, and had definitely not expected the woman sitting across from them to know exactly what the management's legal obligations were from the moment a formal complaint was registered. The meeting was brief, the complaint was accepted, and the clock began to run. The Neighborhood Association contacted Susan that same week. What was said in that conversation was never fully disclosed, but the result was clear. Susan received a formal notification informing her that a complaint had been filed against her for discriminatory conduct, and that the association was obligated to investigate. For Susan, this was likely the first moment in which the seriousness of what she had done began to take any concrete form. Until then, from her perspective, what had happened on that sidewalk was simply a conversation between neighbors. Perhaps uncomfortable, perhaps misinterpreted, but not something with real consequences. The formal notification was the first indication that she had miscalculated badly. Susan hired a lawyer. This detail matters because it reveals something about how she interpreted the situation. She did not go to Diana to apologize. She did not go to the Neighborhood Association to try to resolve the misunderstanding, as she surely would have called it had she had that conversation. She went directly to a lawyer, which means that on some level, she knew she had done something that required a defense. Her attorney began constructing the narrative that was predictable from the start, that Susan was simply being a good neighbor, concerned about the safety of the community, that there had been no discriminatory intent, that everything had been misinterpreted by Diana, and that the formal complaint was a disproportionate reaction to a completely ordinary situation. That defense narrative, the one about the concerned neighbor looking out for community safety, is one of the oldest and most commonly used in cases of racial discrimination in residential communities. It works because it sounds reasonable on the surface. Who could be against neighbors who care about the safety of the place where they live? The problem is that it collapses completely when you ask the right questions. Why was Diana specifically approached and not other residents who were in the area at the same time? Why was the approach immediately confrontational rather than friendly? Why had Susan never approached Diana in this way? Before, during the weeks the two had coexisted in the neighborhood without incident? And most importantly, why was the body language captured in the recording consistent with suspicion and hostility rather than genuine concern? Diana's attorney responded to the defense narrative with something far more powerful than counter-arguments. With evidence. The footage was analyzed frame by frame. Experts in nonverbal behavior were consulted to technically document what anyone watching the video already perceived intuitively. The history of the neighborhood association was researched for other similar incidents, other complaints, other patterns that could contextualize what had happened to Diana, not as an isolated event, but as part of something larger. Every piece of information that Susan's defense presented was found, examined, and answered with surgical precision. Diana was not merely reacting, she was building a case. What was becoming increasingly evident as the process moved forward was that Susan had underestimated Diana in a way that went far beyond that Saturday morning. She had underestimated her knowledge, her determination, and her capacity to transform that humiliating experience into a legal battle that Susan was simply not equipped to win. There is a particular cruelty in discriminating against someone who has dedicated their professional life to understanding and defending the very rights being violated in that exact moment. Susan had chosen, for reasons only she could explain, to confront precisely the wrong person. And now, the consequences of that choice were beginning to take shape in a way that neither of them could ignore. The legal process that followed lasted months, and during those months Susan's life continued apparently normal on the outside, while on the inside it was being systematically dismantled by a body of evidence she had no way to refute. Her attorney did what defense lawyers do in these cases, tried to create doubt, tried to recontextualize what the camera had shown, tried to convince the parties involved that all of this was a monumental exaggeration about a trivial conversation between neighbors. But there is a very clear limit to what arguments can accomplish when a high-definition recording exists, showing exactly the opposite of what the defense is trying to sustain. The recording was the center of everything throughout the entire process. It was formally presented, analyzed by experts, and displayed in contexts that Susan had certainly never imagined when she stood there with her arms crossed on that October morning. Every frame of that video told a story that required no narration. The way Susan had approached, the posture she had maintained throughout the conversation, the expression she wore on her face while Diana answered her questions with the exhausted calm of someone who had been through this before. All of it was there, digitally preserved, irrefutable. And the more Susan's attorney tried to find a way to reinterpret those images, the more evident it became that no reinterpretation was possible. What the process also began to reveal, as it moved forward, was a history that made the incident even less isolated than it had already seemed. Other residents of the neighborhood, most of them black or from other minorities, began sharing their own experiences. None of them had ever filed a formal complaint, for reasons that anyone who understands how these dynamics work recognizes immediately. The fear of not being believed, the exhaustion of having to repeatedly prove what you know happened, the feeling that the system was not built to protect you. But when Diana opened that space by filing her complaint and making the process visible, those stories began to emerge, and they painted a picture far broader than a single incident on a Saturday morning. The neighborhood association, which had initially treated Diana's complaint as a bureaucratic problem to be managed, began to realize it was sitting on top of something potentially far more serious. A documented pattern of racial discrimination in the common areas of a residential community is not merely a neighbor relations problem. It is a legal liability. It is the kind of thing that results in lawsuits not just against the individual who practiced the discrimination, but against the entity that manages the space where it happened and that failed to create a safe and equal environment for all its residents. Diana's attorney had made this very clear from the beginning, and now the association was finally taking it seriously. Susan received a settlement offer several weeks before. The case was set to go to trial. The initial figures were rejected by Diana, who was not conducting this process in search of whatever amount would make the problem quietly disappear. She was looking for a number that reflected the true gravity of what had happened, that acknowledged the harm caused, and that was high enough to mean something beyond a passing financial inconvenience. The negotiations were tense. Susan and her attorney repeatedly tried to frame the agreement as an honorable exit for both parties, as though Diana were doing her a favor by agreeing to close the case without going to trial. Diana did not see it that way, and her attorney was absolutely clear about what would happen if the case reached a jury with that recording as the primary evidence. The final number was $50,000. $50,000 that Susan would have to pay Diana as formal acknowledgement of the harm caused by her conduct on that October morning. But the agreement included more than money. It included a series of conditions related to Susan's future behavior within the neighborhood, obligations to participate in racial discrimination awareness programs, and clauses that made any future incident substantially more costly from a legal standpoint. The money was important. The conditions were even more important, because Diana's goal had never been simply to be compensated for what she had suffered. It was to ensure it would not happen again. The agreement was signed on an afternoon in March, 5 months after that October morning, at the mailboxes. Diana was in her attorney's office when she put pen to paper, and the people in the room described the moment as surprisingly quiet. There was no celebration, no dramatic relief, none of those cathartic moments that movies teach you to expect when justice finally happens. There was only the quiet weight of a long process coming to an end, and the awareness that no amount of money and no contractual clause completely erases what was done on that sidewalk on a Saturday morning. Diana gave an interview a few weeks after the agreement was finalized. She spoke with the same calm she had demonstrated throughout the entire process, the same calm that was recorded in that mailbox video, and said something that summarized with precision what had motivated her to see it through to the end. She said that she knew, from the moment she walked back into her house that Saturday, that if she did nothing, Susan would continue doing the same thing to other residents, to people who would not know there was a camera, to people who would not know what their rights were, to people who would not have the resources or the knowledge to fight back. She had fought not just for herself, but for every one of those people the system leaves without options. The video had already circulated among resident groups and civil rights attorneys before the agreement was even finalized. After the outcome became public, it began spreading in a broader way. People shared it not just out of outrage over what Susan had done, but because of what Diana had done in response. The way she had documented everything immediately, preserved the recording, filed the formal complaint, built the case with methodology and patience, and refused insufficient settlement offers until she achieved a result that truly meant something. She had transformed a humiliating experience into a manual for how to defend yourself when the system tends to protect the one who did wrong. Susan virtually disappeared from the social life of the neighborhood after the agreement was signed. Some neighbors reported that she had drastically reduced her interactions with other residents, that she rarely appeared in common areas, and that when she did, she avoided any contact with Diana. Whether she had genuinely reflected on what she had done or had simply learned to be more careful is impossible to know. What can be said with certainty is that the entire neighborhood had changed after that process. The association had revised its internal policies. The residents who had shared their own experiences during the investigation had finally seen their stories taken seriously. And there was a camera at the mailboxes that everyone now knew was recording. There is something deeply revealing in the way this case unfolded from the standpoint of what it says about power and about who has access to it. Susan had acted the way she did because, on some level, she believed she could. Because people in positions like hers generally can and usually face no real consequences. What she had not calculated was the specific combination of factors that made this case different. A camera in the right place, a victim with specialized legal knowledge, and a determination that did not yield when the system offered the easy exit of an insufficient settlement. Remove any one of those elements, and the outcome would likely have been completely different. That is the most uncomfortable part of this entire story. Because the truth this case leaves hanging in the air, after the money was paid and the documents were signed and everyone's lives moved forward, is that justice should not depend on a camera being in the right place. It should not depend on the victim being a specialist attorney in precisely the relevant field. It should not require months of legal proceedings, considerable financial resources, and an extraordinary determination from someone who had already been humiliated enough. It should be accessible to any person who wakes up on a Saturday morning, goes to get their mail, and is treated as though they do not belong in the place where they live. Diana achieved justice. But she was the first to say that the fact that she achieved it does not mean the system is working. It means only that this time, With this unique combination of circumstances, it did not manage to fail.
Turn that damn camera off right now and show me some ID.
The camera stays on, and I need to know why you stopped me first.
I don't need a reason to stop anyone in this neighborhood, sweetheart.
Actually, you need reasonable suspicion under the Fourth Amendment.
But don't get smart with me. I've been doing this since before you were...
It was a Sunday morning, and Dominique Perryman was on her way to church. She had woken up earlier than usual, had spent extra time getting ready, was wearing her best dress, and had left home with enough time to arrive before the service began. It was the kind of morning that should have had no story to tell. The kind of morning that passes and fades into memory as just another ordinary Sunday. But when she turned the corner of the street where she had lived for the past 6 years and saw the flashing lights in her rearview mirror, something in her stomach recognized it before her brain had time to process it. She pulled over. She lowered the window, and what appeared on the other side of that window was a white police officer with the expression of someone who had already decided how that conversation was going to end before it had even begun. What followed over the next 23 minutes was captured in full by Dominique's phone, which she had discreetly positioned on the dashboard before the officer reached the window. She knew how to do that, not because she was an activist, not because she had a history of conflicts with police, but because she was a second-grade detective with the Franklin County Police Department in Ohio, with 12 years of service, a specialization in crimes against persons, and a record that included more than 140 successful arrests over the previous 3 years. She knew traffic stop protocols better than most academy instructors. She knew exactly what an officer should and should not do in that type of situation. And within the first 30 seconds of that stop, she already knew that what was happening had nothing to do with traffic. The image the video captured, a uniformed officer leaning over her car window, hand positioned near the equipment on his belt, mouth open in a tone that was not a question but an imposition, circulated across the country in the weeks that followed. But before arriving at the moment when that video became central evidence in a federal criminal case, there is a story that needs to be told from the beginning. About who that officer was, what he had done before that Sunday morning, and why the system that should have contained him had failed repeatedly for years before Dominique Perryman crossed his path. Before we go any further, I want to ask you something directly. Subscribe to the channel right now and drop a comment with one word that describes what you feel when you watch a video like this. It doesn't need to be elaborate. One word is enough, because stories like this exist in a space where it is very easy to consume and move on. And what I want is for you to stay, to follow through to the end. Because this particular case has an outcome that most stories like this never have, and you need to see how it got there. The officer who appears in that video was named Craig Welton. He had 14 years in the Reynoldsburg Police Department, a mid-size city in the metropolitan area of Columbus, Ohio. 14 years is enough time to build a career, to earn institutional respect, to accumulate the kind of internal political capital that protects an officer when complaints arrive. And the complaints had arrived. Not one, not two. Public records obtained during the legal process that followed the incident with Dominique revealed that Welton had accumulated 11 formal complaints over the course of his career, 7 of which involved allegations of racially discriminatory behavior during traffic stops. Of the 11, 2 had resulted in verbal warnings. The other 9 had been internally archived with no disciplinary action. Welton had learned, over 14 years, that there was a very high ceiling for what he could do without real consequences. That Sunday morning, he discovered the ceiling had disappeared. The neighborhood where Dominique was stopped was the same one where she lived, where she shopped, where she dropped her children off at school during the week. It was a neighborhood she knew by heart, where neighbors knew her by name, where she had built an entire life. There was nothing unusual about the way she was driving, the condition of her vehicle, her speed, or the lane she was in. The dash cam footage shows this clearly. The camera records completely normal, driving in the seconds before Welton's lights appear in the rearview mirror. There was no infraction. There was no legitimate pretext. There was a police officer who saw a car being driven by a black woman in a neighborhood he had patrolled for years, and decided that was reason enough to act. Craig Welton had arrived at work that Sunday morning 40 minutes early. That detail, apparently irrelevant, came to light during subsequent investigations and was cited by forensic psychologists hired by the prosecution as part of a behavioral pattern that had been documented in previous incidents. Welton had a habit of arriving early on days when he was in the mood to create problems. That was how colleagues who later testified against him described it, with the uncomfortable precision of people who had observed something for years without having the right words to name it. He would arrive early, take the patrol car alone, and head out into the neighborhood with an energy that others had learned to recognize. It was not professional enthusiasm. It was something else. It was the particular disposition of someone who was looking for a specific situation and knew it was only a matter of time before finding it. He had made 3 other stops that morning before pulling over. Dominique's car. Dispatch system records showed this with time-stamp precision. The first had been a black man driving a pickup truck toward the city's commercial district. Welton had stopped him, spent 19 minutes asking questions without issuing any infraction, and released him with no formal record. The second had been a Latina woman in a vehicle with an out-of-county plate. Same dynamic. Prolonged stop, questions with no apparent foundation, release with no documented infraction. The third had been a young black man on a bicycle, stopped on the shoulder of a road where cyclists had every right to be. Welton had stayed with him for 11 minutes before moving on. 3 stops in less than 2 hours, 3 people of color, no documented infraction in any of them. When Dominique's attorneys presented these records during the proceedings, the federal prosecutor described that morning as a pattern of hunting, not patrolling. When Welton's lights appeared in Dominique's rear view mirror, she did what any person trained in stop procedures would do. She pulled over immediately, in a well-lit location, with enough space for the officer to approach safely. There was no hesitation, no evasive maneuver, nothing that could be interpreted as lack of cooperation. She placed her hands visibly on the steering wheel and waited. In the interval between pulling over and the officer reaching the window, which lasted approximately 45 seconds, she picked up her phone from the cup holder with a deliberate movement and rested it on the dashboard, camera facing the driver's window. It was not the first time she had done this. It was a personal protocol she had developed over years, not out of paranoia, but for the same reason any law enforcement professional documents potentially problematic interactions. Because evidence is the difference between what happened and what someone decides to say happened. Welton arrived at the window with the posture the video captured, and that became the image most associated with the case in the weeks that followed. Body leaning over the window opening, right hand resting on the equipment on his belt, expression that mixed performative authority with something that people who analyzed the video described consistently as contempt. He did not introduce himself. He did not state the reason for the stop, which is basic mandatory protocol in virtually every police department in the country. He did not ask if Dominique was all right. He immediately began asking questions about where she was going, where she had come from, whether the car was hers, whether she had been drinking. It was a sequence of questions that corresponded to no known traffic infraction. You do not ask someone if they have been drinking at 9:30 on a Sunday morning without any observational basis for it, such as erratic driving behavior or the smell of alcohol. It was a fishing expedition, an attempt to find something during this conversation that would retroactively justify the stop that had already happened without justification. Dominique answered each question with precision and economy of words. She was going to church. She had left from home on the parallel street. The car was hers, registered in her name. She had not consumed alcohol. Her answers gave Welton nothing to work with, and the video captures the moment he realizes this. A pause of perhaps 2 seconds where he looks into the car, then at the document Dominique had handed over, then back at her, as if recalculating. It was in that pause that he committed the first serious legal mistake. He said, with his body camera running and Dominique's phone recording, that he had stopped her car because she did not look like she belonged in that neighborhood. He did not say there had been an infraction. He did not say driving behavior had generated suspicion. He said she did not look like she belonged there, in a neighborhood where she had lived for 6 years, on a street less than 1 kilometer from her own home. Dominique's expression at the moment. Welton said, that is one of the most discussed elements by those who analyze the video in detail. There was no explosion, no visible emotional reaction, nothing Welton could use to escalate the situation. There was a very slight shift in posture, almost imperceptible, the kind that happens when a person who already suspected something receives confirmation that their suspicion was correct. She had entered that stop as a detective, and she had just received, from the officer's own mouth with the camera running, the evidence that made the case legally incontestable before it had even ended. What happened in the minutes following that statement, the statement about her not looking like she belonged in the neighborhood, was where the stop crossed from administrative misconduct into criminal territory. Welton did not back down. He either did not grasp the weight of what he had said, or if he did, he calculated that there were not enough consequences to justify changing course. He ordered Dominique to step out of the car. There was no legal foundation for that. An order to exit the vehicle during a traffic stop requires the officer to have reasonable suspicion that there is a danger to their safety, or that there is evidence of a crime inside the vehicle. There was neither. The video itself documented that. Dominique was cooperative, hands visible, with no behavior that could be interpreted as a threat. Welton asked her to get out because it was the next step in the escalation he had initiated, not because there was any legal justification for the request. Dominique got out of the car. She made that decision consciously and deliberately, not because she was required to, but because she knew every second of that interaction was being recorded, and that her documented cooperation would make each of Welton's actions even more indefensible in the legal process she was already mentally constructing as it happened. When she stepped out of the vehicle, Welton instructed her to face the car with her hands resting on the hood. It was a search position, the kind of positioning used when there is suspicion that a person is armed or represents an immediate danger. Dominique Perryman was wearing a Sunday dress on her way to church. There was absolutely nothing in that scene that justified that positioning, but she complied. She faced her own car, hands on the hood, on a Sunday morning, on the street where she lived, being treated as a suspect for something Welton was unable to name because it did not exist. It was at that moment that one of Dominique's neighbors, a woman named Patricia Okonkwo, stepped out of her house to put something in the mailbox and saw the scene. Patricia was 63 years old, had lived on that street for 21 years, and had known Dominique since she had moved into the neighborhood. She stood on the sidewalk for a few seconds, processing what she was seeing. The neighbors she knew by name, whose children she had watched grow up, standing facing her own car with her hands on the hood, while a police officer circled around her. Patricia went back inside immediately and picked up her own phone. She did not call the emergency number. She called directly to the non-emergency line of the police department and reported what she was witnessing: a woman being detained without apparent reason in front of her own home. That call was logged with a timestamp and later became part of the body of evidence in the case. Welton spent the next 7 minutes circling around Dominique's car, looking through the windows, opening and closing the trunk, with the permission she had tacitly granted by stepping out of the vehicle without protest. Another element that defense attorneys would later attempt to use, and that Dominique's attorneys neutralized by arguing that cooperation under coercion does not constitute legal consent. He found nothing. Of course he did not, because there was nothing to find. The car was clean, registered, insured, with no irregularity of any kind. When Welton finished circling the vehicle and returned to where Dominique was standing, the video captures a moment that prosecutors would later cite repeatedly in hearings as the point where administrative misconduct definitively became a crime. Welton grabbed Dominique's wrist with his hand, without warning, without justification, without any context that made that physical contact legally defensible, and repositioned her so that she was facing sideways relative to the car. It was assault, simple, documented, indefensible. Dominique did not react physically. The restraint she demonstrated in that moment, watching the video, is of a quality that goes beyond training. It is the kind of control that comes from understanding, at a visceral level, that any physical reaction on her part in that moment, however justified, would be used to reframe the entire narrative. She stayed still, she breathed, and she said in a calm voice fully audible on the recording that he had just committed physical assault against a detective from the county police department and that the video had recorded everything. Welton stepped back one pace. His body camera recorded the moment. Dominique's phone on the dashboard recorded the moment. And Patricia Okonkwo, from the sidewalk across the street, was recording too. What happened immediately after Dominique's words was as revealing as everything that had come before. Welton did not apologize. He did not end the stop. He did not call for supervision. He stood, in silence for a few seconds, then returned to Dominique's car window, picked up the driver's license that had remained on the seat, handed it back to her, and said she was free to go. No explanation, no formal record of the stop, no document indicating that contact had occurred at all. It was as though he expected Dominique to simply take the license, get in the car, and drive away. That the implicit threat of everything that had happened in the last 23 minutes would be enough to ensure her silence. It was the same bet he had made 11 times before, with 11 complaints that had been filed away without consequences. It was a bet he had won 11 times. This time, he had lost before he even knew he was playing. Dominique Perryman did not go to church that Sunday. She got in the car, waited for Welton to move away, and sat there for a few minutes with the engine running and her hands on the steering wheel. Not because she was in collapse. She would describe that moment later in interviews as a period of deliberate organization, not emotional paralysis. She was taking inventory, mentally checking every element of what had happened, every word that had been said, every action that had been taken, in the exact order in which it had occurred, with the precision of an investigator who knew that the quality of immediate memory was a resource that degraded with time and needed to be preserved while it was still sharp. When she finished that process, she picked up the phone from the dashboard, verified that the recording was intact, saved the file in 3 different locations, and sent a text message to her direct supervisor's personal number. The message had 4 words: "I need to talk now." Dominique's supervisor was Detective Chief Marcus Alley, a man with 26 years of service who had supervised Dominique for the previous 4 years and who, by all available accounts, held for her the kind of professional respect that is built over years of working together on difficult cases. He called back in less than 3 minutes. Dominique described what had happened with the same precision she had used to organize the information in her own mind. Chronological, factual, without emotional embellishments that could be used to question the objectivity of the account. When she finished, Allie was silent for a moment. Then he said she should come directly to the department, not touch anything in the car, and that he would be there when she arrived. He also said something that Dominique repeated in every interview she gave about the case. He said this was not going to disappear and that he was going to personally make sure of that. Dominique's arrival at the department that afternoon triggered a series of procedures that the Reynoldsburg Police Department had clearly not anticipated when Craig Welton went out to patrol that morning. Because Dominique was not merely a victim with a video, she was a colleague within the same system. A detective from another department who had been stopped, humiliated, and physically assaulted by an officer while she was off duty and on her way to church. That created an institutional problem of a completely different nature from an ordinary civil complaint. There were implications for interdepartmental relations. There was the question of the credibility of testimony from a witness who was herself a law enforcement officer. And there was the video, which Marcus Alley watched 3 times in a row in a closed room before saying anything to anyone. What Alley did next was what defined the trajectory of the case in a way that Welton and the Reynoldsburg department could not have anticipated. Rather than routing the complaint through normal internal channels, the same channels that had archived 11 previous complaints against Welton without consequences, Alley went directly to the Franklin County Prosecutor's office. Not a phone call. He went in person, that same Sunday afternoon, with a copy of the video on a USB drive and a 3-page written account that Dominique had dictated while he wrote. The on-call prosecutor who received him was a woman named Andrea Voss, who had 15 years of experience in crimes against persons and who, according to accounts from those present, watched the video once, closed the laptop, and asked Alley whether the victim was willing to cooperate fully with a criminal investigation. When Alley said yes, Voss said she would open a formal investigation the following morning. The investigation that followed lasted 6 weeks and was conducted with a level of secrecy that the Reynoldsburg department itself was not informed of its existence until it was already at an advanced stage. This was deliberate. One of the prosecution's first decisions had been not to notify Welton's department until the evidence was completely preserved and the initial testimonies collected, precisely to prevent any internal institutional protection process from interfering with the evidentiary material. Investigators from the prosecutor's office obtained the body camera recordings from Welton's other 3 stops that morning, the ones that had preceded the stop of Dominique. They obtained dispatch records showing the pattern of stops without documented infractions. They collected testimony from 4 of Welton's colleagues who, when confronted with the evidence and informed they were under legal obligation to respond truthfully, provided accounts that painted a consistent portrait of an officer whose behavior had been problematic for years, and whose complaints had been systematically minimized by a supervisory chain that prioritized internal cohesion over accountability. The most devastating testimony did not come from a colleague of Welton's or from one of the previous victims the investigators had managed to locate. It came from Welton's own immediate supervisor, a sergeant named Donald Pruitt, who had signed off on the archiving of 6 of the 11 previous complaints. When confronted with the evidence and informed that the investigation had found documentation that he had been warned about Welton's behavior by other colleagues on at least 3 separate occasions before any formal complaint had been filed, Pruitt made a decision that his attorneys later described as the biggest mistake of his career. Instead of invoking his right to remain silent, he began to talk. And what he said over the following 2 hours not only confirmed the pattern of institutional protection the prosecution was trying to document, it provided details the prosecution had not yet found, and that expanded the scope of the investigation in a way no one had anticipated when everything had begun with a traffic stop on a Sunday morning. What Donald Pruitt revealed in those 2 hours of testimony transformed what had begun as an investigation of individual misconduct into an investigation of institutional conspiracy. He described an informal but deliberate system within the Reynoldsburg Police Department where complaints against certain officers, specifically officers with years of service, with established relationships with department leadership, and with the kind of case closure record that made their presence institutionally valuable, were managed in ways designed to minimize formal consequences. It was not a system written down anywhere. There were no memos, no explicit guidelines, nothing an external auditor could find in a document review. It was a culture transmitted through informal conversations, through verbal guidance on how to document complaints in ways that reduced their apparent severity, through decisions made in off-agenda meetings that left no trace in the department's official records. Pruitt described specifically 3 episodes involving Welton that he had personally handled. In the first, 2 years before the incident with Dominique, a black man had filed a formal complaint describing an almost identical stop, pulled over without infraction, kept for more than 20 minutes, subjected to baseless questions, and released without any record. The man had recorded part of the interaction on his phone, but the video quality was poor and the audio was partially inaudible. Pruitt admitted that he had advised the man during the complaint phase to consider whether he was certain of what he had seen, had suggested there might be a misunderstanding about police procedures, and had framed the complaint in the internal records in a way that classified it as a dispute of interpretation rather than an allegation of discrimination. The complaint had been archived within 3 weeks. In the second episode, 18 months before the incident with Dominique, a Latina woman had filed a complaint alleging that Welton had made comments about her appearance and origins during a traffic stop. There was a witness. The woman's teenage son had been in the passenger seat throughout the interaction. Pruitt had interviewed the boy separately from his mother, without the presence of an adult guardian other than the witness himself, which was a violation of departmental protocol for interviews with minors. During that interview, according to Pruitt himself in the deposition, he had framed the questions in a way that suggested the boy might be confusing the officer's tone with ordinary rudeness rather than intentional discrimination. The complaint had been archived within 2 weeks. The third episode was the most serious of all and involved an allegation of disproportionate physical force that had been completely excluded from the department's formal records. Not archived as unfounded, but simply not recorded as having existed at all. Prosecutor Andrea Voss, upon receiving Pruitt's testimony, made a decision that expanded the scope of the charges in a way the Reynoldsburg Department had not anticipated when the case had begun. She added Pruitt as a secondary defendant in the criminal charges, not as a collaborative witness. And she based that decision on a legal doctrine that is rarely applied in police misconduct cases, but which, when applied, has devastating consequences for everyone involved. The doctrine of liability through deliberate omission, which establishes criminal responsibility for supervisors who, having knowledge of a pattern of criminal conduct by a subordinate, take active steps to prevent that pattern from being investigated or punished. It was not negligence, it was complicity. and Pruitt's 2 hours of testimony had provided the prosecution with exactly what it needed to sustain that argument before a jury. The formal charges against Craig Welton were filed 53 days after the incident in the Columbus residential neighborhood. There were 6 charges in total. Discriminatory stop with racial motivation, which was a crime under Ohio state legislation, reformed following a series of documented racial profiling cases in the state in previous years. Physical assault against a public safety officer, which carried an aggravating factor because Dominique was a law enforcement officer, even while off duty. Abuse of authority, falsification of public record, for the deliberate absence of any documentation of that stop in department records. Obstruction of justice related to the way Welton had attempted to end the interaction without leaving a trace after Dominique mentioned the video. And the 6th charge, the one that transformed the case from administrative to definitively and irreversibly criminal, second-degree kidnapping, because detaining a person by force without legal cause constitutes unlawful deprivation of liberty under the Ohio Penal Code, regardless of how long the detention lasted. When the charges were made public, the Reynoldsburg Department issued a statement saying Welton had been suspended without pay pending the conclusion of the legal process. It was a late defensive response, accompanied by a series of statements from department attorneys, attempting to establish distance between the institution and the individual officer's actions. Exactly the kind of dissociation that Pruitt's inclusion as a defendant made legally unsustainable. Because if a supervisor had actively protected Welton from consequences for years, the institution could not claim that Welton's actions were individual and isolated. The chain of responsibility went up, and the prosecution was determined to follow that chain wherever it led. Craig Welton's trial began on a Monday in March, 8 months after that Sunday when he had stopped Dominique Perryman's car in a residential neighborhood of Columbus. The courtroom was full. Not because there was a crowd of protesters or because the case had become a media spectacle in the most superficial sense of the word, but because there was an unusual number of people with a direct stake in the outcome. Previous victims the investigators had located, colleagues of Dominique from the Franklin County Department, representatives of civil rights organizations that had followed the case since the charges were made public, and a significant number of residents from the neighborhood where the stop had occurred, including Patricia Okonkwo, who had reserved a seat in the front row and who was present on each of the 11 days of trial without exception. Welton's defense strategy had been built on 3 pillars that his attorneys probably knew were fragile, but that were the only ones available given the quality of the evidence. The first pillar was to question the chain of custody of the recordings, to attempt to establish that there was a technical possibility that the video from Dominique's phone had been edited or manipulated between the moment of recording and the moment it was presented as evidence. That line of argument was destroyed in the second hearing, when the prosecution's technical experts presented forensic analysis of the video file that verified its integrity frame by frame, confirming there was no evidence of editing or manipulation of any kind. The second pillar was to argue that the order to exit the vehicle had been justified by security elements not visible in the video, but that Welton had perceived in person. That argument collapsed under cross-examination when the prosecuting attorney asked Welton specifically what security elements he had perceived, and the answers were so vague and internally inconsistent that the jury itself was observed exchanging glances during the testimony. The third pillar was the most desperate of the 3 and revealed just how short of real options the defense had run. Welton's attorneys attempted to argue that the physical contact, the assault for which he had been charged, had been an involuntary gesture, a positioning adjustment necessary for the safety of the procedure, not an intentional assault. That argument needed to survive the video. It did not. Prosecutor Andrea Voss, during closing arguments, paused the video on the exact frame in which Welton's hand grabbed Dominique's wrist, and left that image frozen on the screen for 27 seconds of complete silence before saying anything. When she spoke, she said only that the jury had seen what they had seen, that no verbal explanation could undo what was documented in that frame, and that the question before them was simple, whether that was or was not the definition of unprovoked physical assault against a citizen, who was cooperating fully with a stop that should never have happened. The jury deliberated for 2 days, not because there was doubt about the outcome, but because there were 6 separate charges, and the jury foreperson was a meticulous woman who insisted that each charge be analyzed individually with specific reference to the corresponding evidence before any vote was conducted. When they returned with the verdict, Craig Welton was found guilty on all 6 charges. The room fell silent for a moment after the foreperson finished reading. Then Patricia Okonkwo, in the front row, put her hand over her face, and Dominique, seated beside her attorneys, remained completely still for a few seconds before briefly closing her eyes and opening them again with the expression that people who were present later described not as relief, not as triumph, but as the face of someone who had carried something very heavy for a very long time and had just been given permission to set it down. And sentence was handed down 6 weeks after the verdict. The judge who presided over the case was known for sentences that balanced punishment with proportionality, and there was a genuine expectation that Welton would receive something at the lower end of the range permitted by the charges. That expectation was quickly revised when the judge began reading the sentence. He spoke for 42 minutes before arriving at the number. He spoke about what the case represented in terms of abuse of public trust. He spoke about the pattern of 11 archived complaints and what that said about the institutional complicity that had allowed Welton to continue operating without consequences. He spoke about the specific impact on Dominique Perryman, not just the trauma of the incident itself, but what it means for a woman who dedicated her career to serving and protecting to be treated as a suspect by the very system to which she had devoted 12 years of her life. And then he arrived at the number. 5 years in state prison, with no possibility of early release in the first 30 months, followed by 3 years of supervised parole, immediate and permanent dismissal from the position, with irrevocable revocation of police certification in the state of Ohio. Donald Pruitt, prosecuted separately, received 18 months in prison and dismissal under the same conditions. Dominique Perryman gave a single press conference after the sentencing, outside the courthouse, with Marcus Alley by her side. She spoke for less than 5 minutes. There was no anger in those words, no performative victory, nothing that sounded like celebration of another person's suffering. There was clarity. She said there were 2 stories this case told simultaneously, and that it was important not to confuse one with the other. The first was the story of what had happened to her. A woman on her way to church on a Sunday, stopped without reason, humiliated on her own street, who had fought for what? Was right because she had the means to do so. The second was the story of all the people who had gone through something similar with Welton before her, whose complaints had been archived, whose names had never appeared in a newspaper headline, and who had not received any verdict in a courtroom that day. She said what had happened in that courtroom was justice for her, but that real justice meant the system that had protected Welton for 14 years should never function that way for anyone again. And that part, the systemic change, the real reform, the guarantee that the next 11 complaints would not be silently archived, that part had not yet happened. That part was still to come.
All right, let's make this simple. Show me proof you're in this country legally.
And what authority do you have to ask me that while I'm filling up my
You
car?
don't prove you're a citizen right now, you're going in
I'm a
cuffs.
citizen and a lieutenant with 11 years.
At a gas station on an ordinary afternoon, a black man in a plain t-shirt was leaning against a pump filling up his car. Nothing about that scene was unusual. It was the kind of stop anyone makes dozens of times a year without a second thought. Get out of the car, insert the card, wait for the tank to fill, move on. The sky was clear, the station was busy, and there were other cars and other people around. There were no sirens, no chase, no context that would justify what happened next. 2 ICE agents, Immigration and Customs Enforcement, approached him in full tactical gear, ballistic vests, rifles, faces covered by masks, and blocked the exit with the posture of people surrounding a dangerous fugitive. The body camera of one of the agents captured the exact moment when one of them looked at the man and said, with the ease of someone who believes they are in complete control of the situation, "All right, let's make this simple." What those agents didn't know in that moment, and what the body camera recorded in real time as the situation unfolded, was that the person they had cornered at a gas station with military-grade equipment was Lieutenant Kemba Davis, a black police officer with more than 15 years of service in a metropolitan police force in the American South. She was off-duty. She was in civilian clothes. She was doing exactly what any ordinary citizen would do on a weekday afternoon. And she was about to experience one of the most absurd and revealing moments any law enforcement officer has ever faced on American soil. being treated by colleagues within the same system as though she were an undocumented immigrant, based on absolutely nothing other than the color of her skin. The story of Kemba Davis is not a story about immigration. It is not a story about ICE procedures or border policy or any of the debates that usually dominate conversations when that agency's name appears in the news. It is a story about what happens when racial prejudice is so deeply embedded in a system that it operates automatically without requiring conscious intent, without requiring a declared villain, without requiring any trigger other than a person's appearance. It is a story about how two armed federal agents at a busy gas station looked at a career law enforcement officer and saw something entirely different from what she was. And it is a story about what happened after footage of that moment became public. Before we go any further, I want to ask you something. Subscribe to this channel right now and drop a comment telling me what city you're watching from. Because this story is not an isolated case from a specific state or a specific department. It is a pattern that repeats itself in places, in situations you may have witnessed without fully understanding what was in front of your eyes. And this particular story has a level of documentation and legal consequences that makes it one of the most important cases in recent years for understanding how institutional prejudice operates in practice, not in theory. ICE was created in 2003 as part of the reorganization of the Department of Homeland Security following September 11th. Its stated mission is to enforce federal immigration laws and protect national security. ICE agents have the authority to approach, detain, and arrest people suspected of immigration status violations. But that authority has very specific legal limits. They need reasonable basis to believe a person is undocumented before initiating any compulsory contact. What they cannot do, legally, is approach people randomly based on racial profiling, which means the central question at that gas station was not whether Kemba had documents. It was what specifically had led those two agents to approach her in the first place. And when that question was asked during the legal process that followed, the answer revealed something the department would have much preferred to keep out of the public record. The body cam footage from that day runs less than 4 minutes, but each of those minutes contains layers of information about how power operates, about how authority is distributed unequally, about the gulf that exists between what institutions say they are and what they demonstrate themselves to be when the camera is running, and no one has yet realized that the person being approached has the means to transform that moment into a federal lawsuit. In 4 minutes, two agents built the case against themselves without realizing it. And Kemba Davis, with the composure of someone who spent 15 years knowing exactly how to behave when everything around them is going wrong, let them do it. It was a Thursday in October when Kemba Davis stopped at that gas station in the metropolitan area of Savannah, Georgia. She had left earlier than usual that day because she had a medical appointment and needed to fill up before getting on the highway. She was wearing jeans, a dark blue t-shirt, and sneakers. The clothes of someone who is off duty, who has nothing to prove to anyone, who is living the kind of anonymous and inconsequential afternoon that everyone deserves to have once in a while. She inserted her card into pump number 4, selected her fuel grade, and was waiting for the tank to fill when she caught out of the corner of her eye 2 unmarked black vehicles pulling into the station at a speed and angle that were not those of someone who came to get gas. The 2 agents who stepped out of those vehicles were wearing equipment more appropriate for a high-risk operation in a conflict zone than for an approach at a commercial gas station on an ordinary afternoon. Full tactical vests, rifles at the ready, faces covered by masks, active radios. The agent leading the approach was named Derek Hollis, with 6 years at ICE, most of them in field operations across the southeastern United States. The agent accompanying him was Sarah Pruitt, with 4 years at the agency. Both were part of a special operations unit that had received that day a location order for a specific suspect, an undocumented male immigrant, approximately 35 years old, who had been seen in the area driving a dark-colored vehicle. That was the profile. Vague, imprecise, no photograph, no full name, no identifier that could distinguish the person from any other human being who loosely matched that description. Kemba was 38 years old. She was in a dark vehicle. She was in an area that coincidentally overlapped with the search zone the unit had been assigned. And she was black. That was enough. Hollis and Pruitt made no further checks before approaching. They did not run the vehicle's license plate through the database, which would have immediately revealed that the car was registered to an American citizen with no record. They did not observe the person long enough to notice that her behavior was completely inconsistent with someone trying to avoid federal attention. They did not consider the possibility that the description they had was so generic it applied to a significant portion of the population of that city. They saw what their bias was programmed to see, and they acted on it. Hollis's body camera had been running since the moment he stepped out of the vehicle. The footage shows both agents approaching pump number 4 with Kemba between them and the gas station behind her. It shows Hollis positioning his body to block her left side while Pruitt covered the right. It shows Hollis's rifle not aimed, but in a position that anyone with training would recognize as immediate readiness. The difference between that position and a direct aim was a fraction of a second of decision, and it shows Kemba's face in the moment she realizes what is happening. There is no panic in that face. There is recognition, the kind of recognition that comes from years of training and from a lifetime of understanding that certain moments demand absolute control, regardless of what you are feeling on the inside. Hollis got straight to the point. He said he was looking for someone and needed to verify her identity. He used the tone agents use when they want the other person to understand there is no room for negotiation. Not aggressive in the sense of shouting or explicitly threatening, but with that calculated firmness that is designed to communicate that compliance is the only available option. Kemba responded with a composure that, watching the video, is almost difficult to believe. She asked, directly and without hostility, what the legal basis was for that stop. She did not give her name yet. She did not present identification yet. She asked for the legal basis because she knew exactly what was happening, knew exactly what her rights were, and knew exactly that that question had the power to reveal, in the agent's own words, whether or not there was any foundation for that interaction. Hollis did not have a good answer to that question. What he had was the mission order, the vague suspect profile, and the assumption that the person in front of him was not in a position to challenge federal authority at a gas station with 2 armed agents blocking the exit. What he did not have was probable cause. What he did not have was reasonable suspicion based on specific and observable behavior. What he did not have was any concrete element connecting Kemba Davis to the suspect he was looking for, beyond general physical characteristics that described thousands of people in that city. And when he attempted to articulate a justification, what came out was exactly the kind of vague and circular response that Kemba's attorneys would later use to demonstrate that the stop had never had legal foundation from its very first second. There is a specific moment in the body cam footage that civil rights attorneys described as the turning point of the entire case. Not the moment of the initial approach, not the moment Kemba asks for the legal basis, but the moment that comes right after, when Hollis realizes his answer was not sufficient and decides to escalate. Rather than stepping back, rather than reassessing whether there was any real foundation to continue that interaction, he did what agents in positions of authority frequently do when they feel control of a situation slipping from their hands. He increased the pressure. He told Kemba that her cooperation was necessary for everyone's safety, that the situation could be resolved quickly if she simply provided her documents, and that refusing to cooperate with federal agents on duty could have serious consequences. It was intimidation language built to make the other person feel that the only reasonable way out was to comply, and it would have worked with most people. Kemba was not most people. 15 years in a metropolitan police force, including 6 years in a violent crimes unit where high-pressure situations were the norm rather than the exception, had given her an ability to keep a clear head in circumstances that would cause most civilians to fall apart. She knew intimidation language because she had herself learned to use it as a professional tool. She knew when an approach had legal foundation and when it was theater. And what Hollis was doing in that moment was theater. She responded with a statement the video captured with complete clarity, and that became, in the weeks that followed, perhaps the most shared sequence of the entire footage. She said she understood what he was trying to do, that she respected his role, but that she was also a law enforcement officer, that she knew her rights, and that he needed probable cause to demand her identification, which he clearly did not have. Hollis's reaction to that response revealed something fundamental about the mindset that had guided the approach from the beginning. He was visibly thrown off, not angry, at least not explicitly, but with that particular expression of someone who has built a mental script for how a situation should unfold and suddenly realizes the other person is not following the script. He had arrived at that gas station with a very specific expectation of how that interaction would work. Someone would be approached, would be intimidated by the presence of two armed federal agents in tactical gear, would immediately provide documents, would be checked in the system, and the situation would be resolved in minutes. No part of that script included the possibility that the person being approached would know the law better than he did and have the training to articulate it precisely in the middle of an armed stop. It was at that moment that Pruitt, the agent who had stayed in the background until then, entered the conversation. And the way she entered revealed that there was a real disconnect between the two agents about how to proceed. Pruitt did something Hollis had not done. She asked Kemba directly whether she was an American citizen. She did not ask for documents. She did not assert anything. She asked. It was a slightly different approach, and anyone with interrogation experience would recognize that Pruitt was trying to find a way out of the situation Hollis had created without openly admitting the stop had no foundation. Kemba replied that yes, she was an American citizen, born in Atlanta, Georgia, and that she was a lieutenant in the Metropolitan Police. Then, and only then, she slowly reached into her back pocket, removed her wallet, and presented her police identification. The silence that followed lasted perhaps 3 seconds on the video, but those who have watched the footage describe those 3 seconds as the moment you can see, in real time, two agents simultaneously processing the weight of what had just happened. Hollis looked at the identification, looked at Kemba, looked at Pruitt, and then looked at the camera on his own chest, as if remembering for the first time since he had stepped out of the vehicle that all of this was being recorded. It was not the discovery of the credentials that was written on his face in that moment. It was the calculation, the instantaneous and involuntary reassessment of everything that had been said and done since he arrived at the station, being reprocessed now through the lens that the person in front of him had legal authority equivalent to his own and the means to use every second of that video against the department. Pruitt was the first to speak after the silence. She began saying there had been a misunderstanding, that they were running an operation in the area, that the suspect profile had generated the approach, that there had been no intention of causing any kind of embarrassment. It was the beginning of an apology constructed with the calculated precision of someone who knows they are on very dangerous ground and is trying to find the right words to minimize the damage before the situation escapes completely from their control. Kemba let Pruitt finish. She did not interrupt. She did not display satisfaction or anger or any emotion that could be used to reframe what was happening. When Pruitt finished speaking, Kemba did something very simple. She asked if she was free to go, and when Hollis said yes, she returned the identification to her wallet, the wallet to her pocket, removed the fuel nozzle from the tank with the care of someone finishing an interrupted task, got in her car, and left the station. Hollis's camera followed the vehicle until it disappeared from view. Kemba Davis drove in silence from the gas station to her home. She canceled her medical appointment. She went inside, sat at the kitchen table, and stayed there for a period of time she later described in interviews as difficult to quantify. Not because she was in emotional collapse, but because she was doing something that 15 years of training had prepared her to do in critical situations. She was organizing, reconstructing the sequence of events in chronological order in her own mind, identifying each relevant moment, assessing what she had and what she would need to transform that experience into something that could not be dismissed as a misunderstanding or an isolated incident without consequences. She knew that what had happened at that gas station had a precise legal name. She knew she had evidence in video format that no defense attorney would likely be able to neutralize. And she knew that the decision she was about to make would determine whether that incident ended. As another episode swallowed in silence or as a lawsuit with real consequences for real people and real institutions. She called the police union that same afternoon, not to seek emotional support or to report the incident informally. She called to speak with the on-call attorney and begin the formal documentation process. She described every detail with the precision of someone giving a deposition: time, location, identification of the agents, exact sequence of events, specific words used, positioning of the agents, status of the weapons. The attorney who took her call interrupted her narrative twice. not to ask questions, but to confirm he had correctly understood what he was hearing. The second time he interrupted, he said something that Kemba later repeated in interviews, as the moment she fully understood the dimensions of what she had. He said that what she was describing, if confirmed by the footage, was one of the clearest cases of racially motivated stops by federal agents he had seen in 23 years of labor and civil rights law. The formal request to preserve the body camera footage from Hollis and Pruitt was filed within 2 hours. Simultaneously, the union notified the Metropolitan Police Department, where Kemba served, about the incident, which triggered a series of institutional procedures that ICE had clearly not anticipated when its 2 agents stopped at that gas station that afternoon. Because Kemba was not merely a citizen with violated constitutional rights, she was an active police officer, which meant the incident crossed jurisdictions, involved interinstitutional relations between different public safety agencies, and had implications that extended well beyond an individual's civil action. The Metropolitan Police Chief was personally notified, and his reaction, according to people who were present at that meeting, was one of an indignation that required no rhetorical construction to be genuine. ICE, upon being formally notified of the complaint, initially responded with the standard protocol of any federal agency facing a misconduct allegation: acknowledgement of receipt, opening of an internal investigation, indeterminate timeline for conclusion, language carefully constructed to neither admit nor deny anything before the facts were internally assessed. It was a response that anyone familiar with how these agencies operate would immediately recognize as a damage containment strategy, not a genuine commitment to transparency or accountability. But there was one element in this specific case that made the standard wait-and-see strategy far more dangerous than usual. The body cam footage was ICE property, but the preservation request had been legally filed before any internal decision about the fate of that material could be made. And Kemba's attorney had made absolutely clear in the notification that any alteration, degradation, or loss of that material would be treated as obstruction and added to the action as an aggravating element. 3 weeks after the incident, the footage was released, not voluntarily by ICE. It was obtained through a formal request under the Freedom of Information Act, and when the video was watched for the first time by Kemba's attorneys in a conference room at an Atlanta law firm, what they found was more than they had expected, not only because the footage confirmed every detail Kemba had reported, but because it showed additional elements she herself had not been able to see at the time. Camera angles revealing the exact positioning of the agents, the posture of the weapons, Hollis's expression in the seconds following the presentation of her credentials. It was material that, in the words of the lead attorney on the case, made the ICE defense not merely difficult, but virtually impossible to construct on any argument other than admitting the stop had been a serious mistake. When the video became public weeks later, the reaction was immediate and of an intensity that ICE was clearly not equipped to manage. It was not just social media outrage, though there was plenty of that. It was national news coverage framing the case not as an isolated incident, but as evidence of a systematic pattern of racially motivated stops by ICE agents that had been documented across multiple states in previous years. It was members of Congress demanding formal explanations from the agency's director. It was the ACLU issuing a statement citing Kemba's case as an example of a practice requiring urgent congressional investigation. And it was, above all, the image in that video: 2 armed federal agents blocking a black woman at a gas pump with the caption, "All right, let's make this simple," frozen on the screen. That had the kind of visual clarity that requires no additional narration to communicate what was wrong with that scene. The lawsuit was filed in the federal court for the Southern District of Georgia 42 days after the gas station incident. The document was 97 pages long. It was not the kind of petition rushed together by an attorney who had just heard their client's story and was betting on a quick settlement. It was the kind of document that revealed weeks of meticulous work, every allegation anchored in specific jurisprudence, every violation connected to established federal precedents, every element of the video referenced with precise timestamps and corresponding technical analysis. Kemba's attorneys had built a case that operated on multiple layers simultaneously, and each layer was independently devastating for ICE's position. The first layer was the most straightforward, the Fourth Amendment. The stop had occurred without probable cause. without reasonable suspicion based on specific and observable behavior, and without any concrete element connecting Kemba to the suspect. The agents were looking for beyond general physical characteristics shared by an enormous portion of the population. The petition cited Supreme Court precedents that had clearly established that racial profiling alone never constitutes reasonable suspicion, that vague correspondence with a generic description does not justify a detention, and that the use of disproportionate intimidating force in a baseless approach amplifies the constitutional violation rather than mitigating it. Each of those precedents was applied directly to the facts documented in the video, creating a line of argument that any federal judge with civil rights experience would immediately recognize as solid. The second layer was the Fifth Amendment, protection against compulsory self-incrimination and guarantee of due process. The attorneys argued that the language Hollis used during the stop, specifically the references to the serious consequences of not cooperating with federal agents, constituted coercion, designed to force Kemba to provide information without due process of law. This layer of the argument was more technical, harder to communicate to a lay jury, but was potentially the most costly for ICE in terms of precedent, because if the court accepted that interpretation, it would effectively be saying that the standard language used by ICE agents in field stops constituted unconstitutional coercion in a systematic way, not just in that specific case. The third layer was where the case became truly historic. Kemba's attorneys had done something few firms would have the resources and willingness to do. They hired investigators to research the complaint history against the specific ICE unit to which Hollis and Pruitt belonged. What they found transformed the case from an individual action against two agents into a systemic action against an entire unit and against the supervision that had allowed a pattern of racially motivated stops to develop without consequences. There were records of at least 16 formal complaints against agents from the same unit in the previous 3 years, all involving stops of Black or Latino individuals without documented probable cause. Of the 16, 14 had been internally archived with no disciplinary action. One had resulted in a verbal warning. One had been referred for external investigation and then quietly discontinued. 16 complaints. 0 real consequences. It was the type of pattern that transforms an individual action into institutional liability. And institutional liability carries a financial cost of a completely different order of magnitude. The Department of Homeland Security, under whose supervision ICE operates, was added as a secondary defendant in the action. This was strategically significant for 2 reasons. First, because it expanded the potential financial liability beyond the resources of a single operational agency. Second, and more importantly, because it forced the involvement of a supervisory level that normally remains insulated from the consequences of individual field actions. The federal government defense attorneys assigned to the case made an initial assessment that was described by sources close to the process as concerning for the government. And that is a description government attorneys rarely use about cases they consider manageable. The video was incontestable. The unit's history was documented. Kemba's identity as a police officer with verifiable credentials made any argument that there had been reasonable ambiguity in the situation impossible, and the national coverage of the case had created a level of public visibility that made any attempt at a quiet resolution politically unviable. During the discovery phase, Kemba's attorneys requested documents that the government initially attempted to block under a claim of deliberative process privilege, a legal doctrine that protects internal government agency communications related to the policymaking process. The court partially denied that claim and ordered the disclosure of a series of internal communications exchanged between unit agents, supervisors, and agency attorneys in the weeks following the incident. What those documents revealed was, in the words of the judge overseeing the case at a hearing that became public, sufficiently concerning to warrant an independent investigation beyond the civil action. The communications showed that unit supervisors had been informed about the incident with Kemba the following day, that at least one supervisor had internally described the situation as a misidentification that could be managed, and that there were discussions about how to frame the incident in internal reports in a way that minimized the appearance of misconduct. It was not obstruction in the most technical sense of the term, but it was evidence of an institutional culture that prioritized protecting the agency over holding agents accountable, and that had implications that extended well beyond that specific case. Settlement negotiations began before the case came anywhere close to trial, and the federal government initiated the conversations, not Kemba. That detail matters because it inverts the dynamic that normally characterizes these processes. In cases involving powerful federal agencies on one side and individual citizens on the other, it is almost always the plaintiff who feels the pressure of time, litigation costs, and the emotional exhaustion of a prolonged legal battle, and who eventually accepts a lower value than they deserved, just to bring it to an end. The government counts on that. It builds its strategy around it. It drags the process out, multiplies procedural demands, raises the cost of each stage until the other party simply no longer has the endurance to continue. But Kemba had the police union funding the action, had a law firm that had identified the historic potential of the case and was willing to go all the way, and had a video that became more devastating to the government's position every time it was watched. The government blinked first. The initial proposal the federal attorneys placed on the table was rejected by Kemba's attorneys without prolonged negotiation. It was a number the government's lawyers probably knew would be rejected, the kind of opening offer that functions as a probe, trying to gauge the other party's desperation before revealing how much they are actually willing to pay. The response from Kemba's attorneys was a counter-document that not only rejected the figure, but formally expanded the scope of the non-financial demands in the settlement in a way that made clear the case had never been primarily about money. The demands included the termination of Hollis and Pruitt, the permanent revocation of both agents' federal certifications, the opening of an independent investigation into the 16 previous complaints archived without disciplinary action, the implementation of a revised training program for the entire unit, with annual external auditing, and the creation of an independent oversight mechanism for field stops conducted by ICE tactical units in the southeastern region. The government resisted several of those demands. The termination of both agents was the one that generated the most prolonged negotiation, not because the government believed Hollis and Pruitt were defensible in the face of the evidence, but because conceding on that point opened a precedent that other federal agencies feared. If ICE agents could be terminated as a direct result of a civil action for racial profiling, that created a replicable legal pathway that civil rights attorneys across the country could use in similar cases. It was a precedent the government wanted to avoid at any cost, and Kemba's attorneys knew that and used that knowledge as leverage during negotiations. Every time the government retreated on the termination issue, Kemba's attorneys responded by increasing the financial figure being sought. Of this, and a message was simple: the protection of the precedent you want to maintain has a price, and that price increases with every round of negotiation that does not result in an agreement. The final settlement was signed 11 months after the gas station incident. The full amount was never publicly disclosed, but partial public records and sources close to the process indicated it was substantially above $2 million, with some estimates reaching $4 million when including litigation costs and attorney fees covered by the government. Hollis and Pruitt were terminated. The federal certifications of both were revoked, preventing rehire by any federal security agency. The independent investigation into the 16 prior complaints was opened and resulted, months later, in disciplinary actions against 3 supervisors who had archived complaints without adequate investigation. The revised training program was implemented, and the independent oversight mechanism, though in a more limited form than Kemba had originally requested, was established as a binding part of the settlement. What happened to Kemba afterward followed a path that people who knew her described as completely consistent with who she had always been. She went back to work. She remained a lieutenant. She did not request a transfer, did not seek accelerated promotion using the case's visibility as a stepping stone, did not become a public figure beyond what was necessary to ensure the story was told accurately. She gave selected interviews to outlets that demonstrated a commitment to covering the case in its entirety, and not just its most sensational aspects. And in each of those interviews, she said versions of the same thing that Irvo Otieno had said months earlier, in a different case, in a different state, with superficially distinct but structurally identical circumstances. She said she won not because the system worked for her, but despite the system, that she had resources, training, and specific circumstances that placed her in a position to fight, and that for every person in that position, there were hundreds who did not have those tools and who simply absorbed what had been done to them and moved forward because the alternative seemed impossible. There is a line that connects the case of Kemba Davis to the case of Irvo Otieno and to dozens of other documented cases in recent years where law enforcement officers were racially profiled by their own colleagues within the same system while off duty. That line is not coincidence, it is pattern, and what these cases have in common, beyond the race of the people approached and the absence of any legal justification for the stops, is that all of them only resulted in real consequences because the people involved had the knowledge, the resources, and the determination to transform a humiliating experience into a documented legal action. The system did not correct itself because it recognized it was wrong. The system, it was forced to respond because someone had the power to force it. And that distinction between voluntary correction and compulsory accountability is perhaps the most important thing anyone watching these stories can carry with them when the video ends.
Accountability is a shared responsibility, and facts are your ultimate protection. We appreciate your time and commitment to verifiable truth.